This is Democracy Watch. Mark, we all know about the major Supreme Court ruling barring nationwide injunctions in the courts, but there was another ruling that was almost even more surprising in terms of what the Supreme Court opted to do. Can you explain what happened as it relates to the Louisiana redistricting case?
Yeah, we had all been waiting for months for the Supreme Court to rule in this very, very high profile Louisiana case that involves whether or not the state of Louisiana was correct in drawing a second congressional district after it had been sued for only drawing one. A group of black plaintiffs, including one set represented by my law firm, sued the state of Louisiana, said the Voting Rights Act required a second majority or black opportunity district. The state of Louisiana complied with that court order, and then they got sued by a group of white plaintiffs, saying, "No, no, 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 no. When you drew that, you are violating our rights under the Constitution." And the Supreme Court took this case, which I thought was kind of weird, but nevertheless they took it. We were all expecting big ruling. We get to the last day, and they're rattling through the opinions, and it looks like, okay, the Chief Justice himself may write this opinion because he releases his opinions last. And as soon as Justice Thomas was done announcing his opinion in the pornography freedom of speech case in Texas, the court announced that they were done. And there was a lot of confusion. And we then got an order that said that the Louisiana redistricting case had been held over for the next term. It'll be re-argued, it'll be rebriefed. The questions that are presented to the court will be restated and broadened, presumably. And so that's where we stand as we record this. Although I will tell you the atmospherics around this are not positive.
Atmospherics are not positive for which side?
Look, here is the deal. There is not a lot of good reasons why the Supreme Court took this case. There are even fewer good reasons. If you care about free and fair elections and you care about voting rights, there are even fewer good reasons why the Supreme Court would want this case re-argued. So
Right.
my fear, my concern, and I think the concern of many in the pro-democracy community, is that they want to use this case to see whether they want to overturn the Voting Rights Act in its entirety, or at least severely cut it back in the area of redistricting, and that they wanted that process to go forward, but that they wanted there to be more briefing and argument on that question. But we're going to find out soon enough, because probably in the next week or so, the court will release what the question is, or questions that they want the parties to brief are, and then we'll know for sure.
And you can glean based on those questions the direction that the justices are interested in for this next round of arguments. Is that correct?
Yeah, so for example, if the Supreme Court comes back and says, look, the question we want you to brief is whether or not the Voting Rights Act's reliance on race to draw congressional districts violates the U.S. Constitution's Equal Protection Clause, it's a pretty good indication of where they're going, right?
But
And again,
if the question here was not, this is just about the specific, the narrow a question of the legality of Louisiana's map. So where did the Supreme Court justices get off saying, you know what, we're going to use this as a vehicle to decide something that wasn't even in question in this case? How can they use this case as a vehicle to determine whether or not to overturn the entire Voting Rights Act if that's not what this is about? Isn't that an overly gratuitous use of their power here?
yes, and it would be. And by the way, it is not lost on me that they did this on the same day that they issued an opinion in which they said essentially the judiciary should not exercise too much power in making sure Donald Trump doesn't
Right.
violate the civil and constitutional rights of millions of Americans, right? So, like in that case, they were kind of throwing up in their hands and say, well, what are the courts are not that powerful, not that much we can do,
Yeah.
if Donald Trump issues these orders. But here, if they then decided to order this re-argued on a broader set of claims than even the parties sought, yeah, that should definitely raise some eyebrows.
Has this kind of thing happened before? Do you see the Supreme Court just decide unto itself that they're not going to issue a ruling in a case they've already heard because they want the litigants to just argue it again?
All right, I just want everyone to know that Brian and I do not coordinate what these questions are in advance. So but I'm glad Brian you asked because you know the last time that the U.S. Supreme Court did this,
When?
it's a small case called Citizens United. Citizens United was a case that was brought to the U.S. Supreme Court on the narrow question of whether or not pay-per-view movies were covered by a provision, a very sort of arcane provision of the federal law that governs paid public communications made within 60 days of a general election that are aired on cable broadcast or satellite. So the question was whether pay-per-view movies meet that definition where they are, where you have to pay for a movie.
Yeah.
And Citizens United had made a movie called Hillary the Movie, and they thought that they should be allowed to put this on pay-per-view systems around the country. And that case goes to the U.S. Supreme Court, and like here, at the end of the term, the Supreme Court said, you know what, we don't want to decide that question. Instead, we want you to rebrief and argue the question of whether or not corporations have an absolute right to make independent expenditures in connection with federal elections. And everybody was looking around being like, wait a second, Citizens United's not looking to do any of that. They just want their movie on like cable pay-per-view
Yeah.
systems. But that's how we wound up with the Citizens United decision.
So in theory, I mean, there is precedent for the Supreme Court taking a narrow question and extrapolating it into something that would ultimately be extraordinarily damaging to our democracy.
Right, but also taking a question that the parties themselves actually didn't want to litigate.
Right.
Right? I mean, like the thing about if they do here what they did there is that in both instances, look, the plaintiffs in Louisiana and the state of Louisiana are more than capable of making arguments that the Voting Rights Act is unconstitutional. Like this is not a crowd that is overly sensitive to the Voting Rights Act, right? But they didn't make that claim in the
Right.
Supreme Court. They made a different claim, and like I said, it is beyond ironic that on the same day they are suggesting that this case needs to be held over for another term, they went about saying that when district courts say that Donald Trump cannot strip citizenship from millions of Americans, that the Supreme Court was like, well, whoa, courts can't go that far. You
Right.
can't do that.
Except
That's too
for
much.
except for our court that can decide that we're going to use a narrow question in this redistricting case to determine whether or not we want to overturn and gut the entire Voting Rights Act. That's fine.
Right, which was enacted in 1965, which has been amended and reaffirmed over and over again. And by the way, the law about the Voting Rights Act and redistricting goes back to 1982, and I don't have the exact number, but there have been at least several dozen cases that the U.S. Supreme Court itself has decided deploying the Voting Rights Act. So I mean, like this would be this would be like all of a sudden in 2025 being like, wait, so for the last 60 plus years we ourselves have been applying a law that we've now decided actually doesn't pass constitutional muster.
So this question is going to seem like it was plucked from the depths of resistance Twitter, but every single one of these Republican justices on the court made a promise during their confirmation hearings that they would respect stare decisis, that they would respect this idea of precedent. If and hopefully not when, but if and when they do have the opportunity to do exactly that as it relates to this case in particular, the Voting Rights Act, which you just explained has been reaffirmed over and over and over again, is there a situation where, okay, now you have people who've just proven that they said one thing in their confirmation hearings, lied under oath. As soon as they had power, they exercised it in a way that was completely antithetical to what they promised in their confirmation hearings. Is, like, I know that we hear the usual cries of, okay, well, these people committed perjury or they lied under oath. And so how do we think about that? Or is this just a completely unaccountable system where, unfortunately, there's nobody above the Supreme Court justices, so they can lie their asses off in their confirmation hearings and, say one thing, do another once they actually have power?
Look, they would say that stare decisis is a factor, but it is not controlling. I mean, look, they had to deal with this in Dobbs. I mean, in Dobbs, as Justice Kavanaugh testified when he was before the U.S. Senate for confirmation, Roe was precedent upon precedent, right? I
Yeah.
mean, like you had the original Roe case, you had several dozen cases that had applied Roe at the Supreme Court, but then you had Planned Parenthood versus Casey, which reaffirmed Roe under stare decisis. So literally, they had already decided the stare decisis issue in Roe, but then Dobbs came and they changed their tune. And you know, we talked on about this with respect to the other ruling today on an earlier video that you know the Supreme Court has been upholding injunctions that are nationwide or universal, pick your terminology, you know, for years and years. And during the Biden administration was constantly facing situations where district court judges who had been forum shopped in some instances had issued injunctions on a nationwide basis, you know, against the Biden administration. Biden administration didn't like it, but the Supreme Court didn't say that the courts were powerless. So
Right.
there does seem to be a little bit of turnabout here in some of these things. And, you know, I hope, you know, when we get the questions presented, you and I can come back to this and talk about whether that is what's happened here, what the likely road is. But I'll also tell you that there is another case that we're waiting on from the Supreme Court, also to get an order next week involving a campaign finance issue. It's a case that I'm involved in personally. The Supreme Court upheld limits on party coordinated expenditures with candidates going back to 1976. They reaffirmed those limits in a direct challenge to them in 2001 brought by the Republican Party. And the Republican Party is asking them again to revisit that and overturn that. And we will also find that out next week. So next week is going to be a big week for democracy on the docket.
And I know that you've been covering all of this extensively on both Democracy Docket, which is the news outlet you founded to focus on everything voting and elections, and also Democracy Docket, your YouTube channel. So highly recommend for everybody who is watching right now, if you have not yet subscribed to Mark's YouTube channel, completely free to do that. These are the exact kind of voices that we need to elevate in this media ecosystem. So if you're not yet subscribed, go ahead and subscribe. Again, it doesn't cost you anything to do that, but we need to elevate good pro-democracy voices in this ecosystem. I'm Brian Tyler Cohen.
I'm Mark Elias.
This is Democracy Watch.